Thank you. I'd start off by saying that we take a somewhat different approach, I think, than most law schools do to the way that we integrate technology into the curriculum. And I want to start off just talking about the unusual path by which we got there, and sort of what lessons that we've drawn from sort of what's useful for lawyers of the future to know. And I also want to kind of begin by saying I don't necessarily think that our course is right. I think this is an evolving area where we're all kind of learning that whatever we come up with, a better answer may well come along, tomorrow. And I also think one of the really interesting things that's happening now with technology is there are so many different ways to integrate technology into law teaching, because there's so many different ways lawyers can make use of this technology that unlike most law school curriculum offerings, most all of the rest of the law schools or rest of law school is kind of the same. Everyone offers torts, contracts, civ pro, etc. And there's some like tinkering around the edges. One of the great things that I think is happening now is that because there's no real one way for lawyers to use technology in this world, law schools are coming up with very different ways to address what they think will be useful to future lawyers. And I think that creates a wonderful market differentiation that allows students to kind of choose among what we're all doing. Ours, I say, is a kind of idiosyncratic view that grew out of an experience I had many years ago. About 7 or 8 years ago, look, my background is also very unusual for someone doing technology in law. I was a history major. I got my law degree and then got my doctorate in legal history. I wrote my first code at the age of 50. I'm now 56. So I'll offer that to say that, don't think you're too late to join this bandwagon and don't think you can't catch up. So I was teaching crim law, crim pro, evidence, a little legal history, a little con law. And every year when I would teach in crim pro, probable cause, reasonable suspicion, I would always get to this point where I would say, look, I can't really tell you what the answer is. I can tell you, like every good lawyer, here's the way you argue that you have probable cause. Here's the way that you argue against it. You find the most analogous case. And of course, that's true in a lot of areas of law. But it seemed particularly unsatisfying. You couldn't really find a real poll star for reasonable suspicion of probable cause. And, ideally it would be an amalgamation of all the cases that existed in the universe, but you really couldn't assemble those in any meaningful way. So the very specific question we started off trying to address was a question in a drug interdiction stop. I don't know how familiar you are with crim pro. I'm sure some of you have great insights on crim pro, and some folks have took the class because you had to. But there's this fact pattern that recurs over and over again in criminal procedure. An officer sees a person speeding, pulls the person over, looks around inside the car, sees some basis for thinking there might be drugs, holds the car until a drug dog can come and sniff the car. All my slides are AI generated today, and I asked, this is Gemini, and I asked Gemini to include as the old-timey cars to look fun. And then I have a Bernese Mountain Dog, so I asked it to include a Bernese Mountain Dog. They do not use Bernese Mountain Dogs for drug sniffs. There's this wonderful meme on Instagram. It has all these different dogs. I save lives. It's a rescue dog. I guide the blind. I think it's a Labrador. A German Shepherd. I test for drugs, and there's a Bernese Mountain Dog that says, I like cheese. The Bernese Mountain Dog would not be doing any kind of real police work, but that's why I kind of thought it'd be fun to put in there. But drug dogs sniff for drugs. And you have to have a certain basis of suspicion to hold the car for a drug dog. And the question is is there some way we can predict whether, based on all this corpus of cases, that we have reasonable suspicion, something that an officer could actually use, because an officer couldn't read the 10,000 cases out there, the 100,000 cases out there, and determine this. lawyers can't do it. Is there some way a machine can do this? And is there some guidance we can look for in a way to come up with a model? This is what I was thinking about before I started this project. Is there something in the annals of technology or in the annals even of science fiction? One of my colleagues, Dan Breen, in his faculty job talk, did this wonderful presentation on science fiction, in which he said, look, many of the great technological advances first appeared in works of science fiction, and should those things be patentable? Or do you have an intellectual property right in those things? So I began to ask the question, just kind of jokingly, are there science fiction examples of using multiple factor analysis to come up with predictions? And in fact, there is. Let's see, play. Oh, it's not going to play for me. There we go. Oh, crap. Here we are.
Finished. Wiley, you're such a genius. Now, to see what our little friend is doing. Now, let's see. Rabbit. Hole. Combination lock. Yes.
And then, of course, it tells us how to solve this problem. So this was, this is kind of jokingly the idea we had. I've used the Wile E. Coyote example many times when I present this. Could we come up with something like this? This is where the project began for me. And I happened to Google, this was like 2000 and I'm going to say 15, 16. Google the question, what law professors work in the area of, computer science and law, AI and law, that sort of thing. And I land on one of our co-presenters today, or one of our presenters today, Kevin Ashley. If you're looking for a rock star in the room, he is certainly one of them. He began teaching at the University of Pittsburgh, doing AI and law in 1989. You want to look at like forward thinking. He's teaching AI and law at Pitt at 1989. Met with him, and I said, I've got this idea. And I don't know if you remember what you told me, Kevin, but you said, this is going to take a long time. This is going to take years of work. We're what now, 2026? We're 9 years in, right? And the other thing, I talked to Kevin, I said, I've got this student who has just started working with me. He has had like one computer science class in background. I think he'd be great for a PhD program. And we started talking. That guy, Morgan Gray, is about to finish his PhD with Kevin. So a lot of great things came out of this conversation. And this is the first time that, Kevin, you and I have been invited separately to present at a conference. To me, this says I've now made it. This is a wonderful event for me to be at for that reason alone. So he and I began working with Morgan and with Jaromir Savelka, another of our colleagues who now teaches at CMU. These are some of the papers we presented. And this was great, right? This is beginning to work on using all these techniques of text analytics and predictive analytics to try to come up with some definition of what this multiple factor analysis would be. And that would be great. That would be wonderful if that was all the work we ended up doing with this. And there's certainly a model. There's certainly a model for a great theme that you can aspire to when 4 white men get together and work on multiple projects together. And that would look something like this. My wife was right. That didn't get a laugh. And now it does. But I was actually looking for more applicability to this. Is there something more we can do than just our own project? What if other lawyers began to think about this question, began to know that there might be ways to connect what you read in case books to ways that we could think about automating processes, to ways we could think about making predictions? Would it help lawyers to get just a taste of computer science? And that's where we began this. We started a class called Coding for Lawyers, thinking that if lawyers just began to think about computer science, then they too would develop ideas like ours. in totally different areas. We had no idea where this would lead. And then in 2024, we introduced a class on statistics and machine learning for lawyers. And so, like, what did these early classes look like in 2022? I'm amazed that WVU began teaching things on GPT in 2020. This is wonderful. I didn't know it was on the horizon in 2020. But in 2022, we began teaching a class that was very syntax heavy. That the idea behind it at that point, we didn't fully know why we were doing it, other than to say, maybe this will inspire more ideas. There are some document assembly things you can learn to do. There are some, with a little bit of knowledge, that this would be a good starting point to whet an appetite, but we weren't entirely sure where we were heading with all this, and it was a very syntax-heavy class. Think about how to write these things. Think about kind of, some architecture of codes. Think about how to build things, and that will inspire stuff. But at that point, you had to start with getting folks familiar with how to write these things, how to get the periods and commas in the right places, how to debug, because the code wouldn't run without it. And as we moved to statistics and machine learning, again, we weren't trying to create anything complicated. We were trying to give folks an introduction to these ideas. And so we began with R, because any of you in the room who have a background in data science will know that for ages, R was the language of most used for folks who did statistics and machine learning. And then a whole lot of things began to change, as you know. One of the kind of stories that hasn't really been talked about today, for completely understandable reasons, is sort of how Python has become the English of programming languages. That Python really has, everyone seems to be gravitating toward Python. A lot of development's occurring in Python, and packages are being developed for it. And so it really made a lot of sense, since we were doing the first class in Python, to then move the second one to Python as well. The graphics for Python are getting better and better. And so that was kind of the small innovation. The big innovation was, of course, generative AI. And that raised a whole bunch of questions for us. What is it exactly that we're teaching now that you can teach a computer to write code, or you can prompt a computer to write code? What is the insight? Previously, it's like, with the syntax we're giving you, you'll now think about what computers do, maybe think about building things, maybe think about joining with computer scientists, as Morgan and I did to work on this first project, kind of a whetting of the appetite. But if the machine itself can write the code for you, what then? What is it that we should teach? What will you do with these skills? And then kind of the grander question, what work is left for human lawyers? What work is left for humans as a general matter if these codes that we're writing can then automate a lot of legal processes and a lot of legal decision making? So I offer our current thinking on this, which I say these things are in flux. I have radically altered the two classes I teach every single year as I've learned more and as the technology has moved more quickly. But the answer we've arrived at is, like, our view of what lawyers will be doing is our value add to this world is if we can understand both the world of law and the world of computer science enough that we can explain what's going on, not at the crazy level of complexity of, like, the neural network that creates that runs OpenAI. Obviously, like, no one really fully understands that. But if you can understand, explain, criticize the methods that are being used, ask the right questions of what's going on with these things, then your role as a lawyer increasingly is going to be either you've got a client who is suing someone who has made an automated decision. You're defending someone whose company's made an automated decision. You are you're working with the legislature to regulate these processes, or you're working with a tech company to build various devices. All these things will require the lawyer to have enough of an understanding of how these processes, of how computer systems work. And at the same time, generative AI is giving us the ability to teach so much more quickly to students how to write code. You no longer have to worry about getting the comma and the semicolon in the right place. So how have our classes gravitated? And we've moved them in a way that we think will benefit, will assist the lawyers of the future in operating in that gap. So this book I read about a year ago fundamentally changed the way I think about this whole question. Anil Ananthaswamy's Why Machines Learn. Anil Ananthaswamy is a wonderful writer. He was a programmer in the 90s and then left that behind to pursue science journalism, and then comes back during COVID to do a fellowship on science journalism at MIT. And while there, he revisits his programming background and decides that too many of the popular science works on AI skip over the math. And he says, look, in order to understand what these things are actually doing, you've got to understand the math. To talk about it, you've got to understand it. And I love this quote on page 4 of the book. If we are to effectively regulate this extremely useful and disruptive and potentially threatening technology, another layer of society, educators, politicians, policymakers, science communicators, and even interested consumers in AI, must come to grips with the basics of the mathematics of machine learning. You need to understand the math to understand the intuition behind what this stuff is doing. So in our statistics and machine learning class, I've very much taken that to heart. For those of you who've had a statistics class at any point in your lives, you'll probably remember that usually the way they do this is they show you how to do an equation to get the slope of a straight linear regression. And they say, look, anything more complicated than this is too hard to do. Just plug it into the machine, and here's how it works. So Ananthaswamy's book is so wonderful because he says, look, you have to start off understanding the basics of linear algebra and multivariable differential calculus. I now begin my statistics and machine learning class with a crash course in linear algebra and multidimensional differential calculus. They then build the early models from scratch. They walk away with an intuitive understanding of how gradient descent works because they now view it from creating this thing with no package, just typing in the equations in linear algebra format. We even go a little bit into the electrical engineering of it. Why is it that linear algebra is used? Because the machine is able to calculate things in that format very quickly that it couldn't do in if it used other methods of computation. So we get the intuition, we play with the models, and they actually then build these devices. We're actually working on a bail algorithm this semester, and we're talking with a judge in Virginia with this publicly available available data in Virginia, and they're critiquing it, but they built this thing from scratch, working on something called a method called linear logistical regression. For those of you who are familiar with that. So then we go back to our basic class. That's the advanced class, the statistics and machine learning. What do we do then with the intro class? That was for all intents and purposes, the first year of its existence. Just here's how you understand loops and lists and dictionaries and object-oriented programming. What are we now doing with that? I love the fact that Josh Fairfield talked about a lot about concerns of cryptography. We actually now, because we can do it with these generative AI models, because we don't have to worry about teaching syntax to teach folks how to work in code. We begin that work in that class to actually learning encryption methods, and we learn the math behind it. So they learn what AES encryption is. They work on a code to create AES encryption and RSA encryption. The one is a very lightweight system that uses the same key to encode and decode, and then the other one is a very, very heavy system. It takes a lot of computational power, and basically you lock up your key with the one and you send it with the other. And we learn that process, and they actually learn the math behind it. So at the end of this class, when folks are talking about concerns about quantum computing and how it will crack all of our encryption methods, they're capable of saying, yes, here's how that will happen, because this is how RSA works. Shor's algorithm works this way, and it will crack RSA encryption using the following method. And that's why we currently believe that lattice-based encryption methods will actually be secure in a post-quantum world. My theory is that a lawyer who can talk like that, who can meaningfully have that conversation, not that you're going to go to court and talk about the modulo function with a judge, but that level of background knowledge grounds you in ways that you are now able to talk to the computer scientists who are actually building the things, as well as the clients and the law firms and the courts when you're dealing with these issues. There's a grounding, there's a comfort level you get by understanding fundamentally how that works. The next step of that then is we are now taking all these methods and integrating them into projects that we have worked on with the Duquesne Clinic. And I'll hand it off now to my colleague Kate Norton, who is the director of clinical programs, and she's going to tell you about some of the work that we've done with students who have then learned all of these methods.
With the coding work we do. And I know Wes just talked about a bunch of math that if I know my students that they like to tell me, well, I went to law school because I don't like math. I then kindly remind them in the family law clinic, well, you do know how to read a tax return. This is how we divide marital estates. Oh, and if you go into the criminal world, mandatory sentences and minimum sentences are done in months, not years, so you do have to do that math. So it's not as scary as it sounds. We all have a basic fundamental understanding of the math, and you can get there to have that language to talk about it. And that's what we do when we integrate it into our experiential learning. So for those of you who are unfamiliar, the ABA requires all law school graduates to have a minimum of 6 credits of experiential learning prior to graduation. Excuse me, the allergy season is bothering me as well. This can be through a simulation. Mock clients, not real necessary cases, but clients that are based on factual situations you might see in the legal world to then do the work, drafting contracts, arguing a trial, mock trial, things of that nature. Clinics, that's where my world is, where we're working on live cases of individuals who have needs that my students are representing them in court. Or field placement, which is where, yes, they're in a seminar at the law school, but then they go out to governmental entities, judicial placements, or nonprofits to do work in the field. So the core of experiential learning is students are learning the skills of lawyering, interviewing, counseling, oral and written advocacy, problem solving, critical thinking, how to manage client expectations, time management. My favorite thing I teach my students, how to bill. If you'd like to be a lawyer one day and want to get paid, you do need to know how to break your day down into 6-minute increments. Clinical education is also a space for professional identity. We do have to, according to the ABA, offer students an opportunity to start to build their professional identity, which is how you fit into the legal world. What's your role and your responsibilities to clients, the public, and even creating a just system. So that kind of leads us to what the dual role of clinical education is. So Professor Rode, who is one of the greatest advocates on access to justice and teaching in this kind of dual role, stated in her book, Access to Justice, over 2 decades ago, that legal education plays an important role in socializing the next generation of lawyers, judges, and public policymakers. As the gatekeepers to the profession, law schools have a unique opportunity and obligation to make access to justice a more central social priority. So as we're working with our students in clinical education, we're also teaching the need to make sure that our system is accessible to everyone. And why do we do this? Well, the Legal Services Corporation issues a report about every 4 to 5 years called the Justice Gap. The Legal Services Corporation is one of the main funders of legal aid in the country. And so they reach out to their grant recipients and ask every year, give us your statistics. Let us know what's going on in the legal aid world. Because the data is only based on what the organizations that they fund and what the organizations report on, I run a grant-funded clinic by our local IOLTA, which means I report on what my clients are willing to share because confidentiality still applies. So what all this means is these statistics are woefully underreported. So even with knowing that it's underreported, 74% of low-income households in 2021 had a civil legal issue. This is issues dealing with family law, employment, housing, benefits, healthcare, pretty much everything that affects our day-to-day lives. And 92% of them did not receive any or enough legal help. So why? So basically 1 out of 2 people that received assistance didn't receive enough or any. And it could be due to limited services, things that are not, we don't provide full representation in civil matters. This isn't the criminal world. We don't have a right to counsel in civil matters. So why could it be? Well, there's also a variety of hurdles that impact low-income Americans when they need to access justice and deal with their legal issues. So this can be the bandwidth. A priority for someone who is in a low-income situation has to be food, shelter, providing for their family, their day-to-day needs. The view of the issue. I know a lot of folks that come to me with a child custody issue often tell me, hey, I should just be able to work this out. This is a family issue. Why do I need court intervention? So they don't view the issue as something that should be decided by a court. Maybe they don't understand the substantive law. Maybe they don't understand that there's a bazillion factors in Pennsylvania that go into determining what the best interest of a child is in a custody determination. Maybe they don't understand the procedural laws. I was telling Wes and Marty when we got here today that one of my cases we just sent out, we were trying to get somebody from their custody of their child when no one was opposing it. We still had to send about 40 pages of documents to the other side, even though they weren't opposing it. So maybe they don't understand all the procedure and all the documents that have to go into getting things out there to move their case forward. The mundane aspects of litigation, where to stand, where to go, how to get into the courthouse, how to file things, or just the costs. And we're not talking just about lawyers' costs. I know lawyers can be very expensive when my clients come to us, but we offer free services. But there's also the costs of transportation, childcare, missed work, court costs. Fun fact about the Allegheny County court system, which is located in Pittsburgh, where my students practice, is the most expensive parking lot in the entirety of the county is right across from the courthouse. Something like $50 a day. So those costs all contribute to why folks don't address their legal needs. But as we kind of heard about a little bit already today, there's also legal deserts, where there's potentially no help available. So according to the ABA, a city or a county with less than 1 attorney for 1,000 residents is considered a legal desert. So I have a bunch of statistics about Pennsylvania and Virginia because they're kind of comparisons and we've presented in those places before on this issue. But in Pennsylvania, there's about 3.8 lawyers per every 1,000 people. Not too bad. We're better than 1 per 1,000, especially compared to Virginia, where 60 of its cities and 133 cities and counties actually are considered legal deserts. So I did some quick math. Basically, I counted up on a spreadsheet, I'm going to show you in a second, that 24 out of the 67 counties in Pennsylvania have less than 50 lawyers. 4 of those have less than 10 lawyers. Approximately 90 of the 133 jurisdictions in Virginia have less than 50 lawyers. So what's this look like? So as you can see, each little purple dot is 10 lawyers. So in Pennsylvania, Allegheny County is doing okay. The Philadelphia area is doing excellent. Middle of state around Harrisburg, it's okay. Everywhere else, not so great. So all of this contributes to why we've been looking for solutions to the justice gap forever. Historically, these solutions can be from a civil Gideon, the concept, well, we have guaranteed representation in criminal matters, why not civil matters that impact lives so significantly? And then kind of on the less intrusive end, the self-help materials. You don't know what you're doing in court, that's okay, here's a pamphlet, let us help, this could guide you through at least filing, let's say, a custody complaint. But over the past couple of decades, we've actually shifted to looking into the utilization of technological tools and AI to address the justice gap. So for example, for the past 25 years, Legal Services Corporation has actually been giving technology innovation grants to legal aid organizations to start to do this work, create client intakes that are automated and not complicated for the litigants that need their services. Trying to make legal services more efficient, effective, and accessible. So this is how we get to what we're doing at Duquesne Kline. We've combined our coding and our clinics to kind of focus on, what does a tech lawyer look like? In doing it in our realm, the reason why we look at this way is it provides a unique opportunity to make sure that the technology that's being developed, the utilization of it, is done in an ethical manner. The core of what you're learning in PR, if you're a student, we have to keep confidentiality. We have to make sure that there's no conflicts of interest. Those kinds of core tenets of our rules of professional conduct, making sure that the technology we're utilizing is not violating that in any manner. But also, as we talked about in our introduction this morning, making sure that the technology and the AI that we're using is not making it harder for individuals and creating a greater justice gap. We want to make sure as AI advances, and those wonderful tools that we get to use, like Westlaw and Lexis and their, Protege and all of their new bells and whistles, well, my pro se litigants can't afford those programs and can't utilize it. So what kind of AI is available to them and can it be utilized? Also, how to critically evaluate the limitations of the technology. One thing that we focus on in the programs we're going to talk about in a few seconds is it available on a cell phone? Almost everyone has a cell phone, a smart device that they have access to, and that's how they interact with the internet. How can we look at some of potentially the hallucinations or maybe the potential assumptions that the AI that we're utilizing is giving us? For Wes and I presented, I think it was Georgia, and I asked Microsoft Designer, give me a slide of a family law professor who is interested in AI and access to justice. It gave me a picture of an individual in a black robe with a gray wig. I can promise you I do not wear a gray wig to court, ever. I try to hide the gray, actually. So that's one of the things that we're looking at. We're also developing traditional lawyering skills. Our students who work on these projects are questioning, they're interviewing, they're talking to the stakeholders. It's always client-centered programming that we're trying to develop. How does this empower the clients that we work with? And it's always with the goal of trying to assist in closing the justice gap. So here's kind of the partnership methods that we've created between our coding programs and our clinics and our experiential learning in general. One is the development of code within specific clinics. Probably 4 or 5 years ago, we received an ABA initiative grant where we were able to create a family law appellate program. This was done within the family law clinic, utilizing the students in the clinic, as well as they had some crossover with the students who were in Wes's coding class. And they created a program to help get individuals into a underutilized custody appeals pro bono program. We had it, it's been in existence for years, but no litigant would use it because they didn't know how to navigate the application process. So we created an automated application that the students and volunteer attorneys could utilize to help get litigants into the program. The students through this process evaluated the code, put in the different legal statutory requirements, were able to see kind of the underbelly of what the code looked like as it got built so that they knew the pitfalls and the benefits of the code that we were using. Another kind of partnership method we use is actually partnering with the Coding for Lawyers class to develop legal aid programs for the clinic. In Wes's class, they have a final project that they have to do, and often that is pairing with the clinic to develop automated intakes for our clients, income screening verifications. We are an IOLTA-funded program, which means all of our litigants have to be at the 187.5% of the poverty guidelines. Yes, which is also why we all still do need to know how to do math, because we have to do that calculation daily. But now we have a program that will help with us. We also do independent studies under the clinical program to develop legal technology programs to be piloted in the legal field. We're currently working on one. One of our counties requires that any time an individual files a protection from abuse action, there's a domestic violence situation, they receive a temporary order. If a child is listed in this, they are also required to instantaneously file a custody complaint. So, as I said a few minutes ago about my students struggling with all the paperwork that we had to sign, that custody complaint is that 40 pages of documentation that has to go out before they will even be considered for a final protection order. This is really complicated for low-income litigants without representation. So, our students who have been working on this project have created programming to kind of, I would equate to a hot doc, but a very intense hot doc, to help litigants do that automated custody complaint as they're filing for their protection from abuse. And Wes, I don't know if you want anything to add about the project.
The security aspect of that's what makes it so complicated, because you've got to transmit this stuff across the internet. And so all the encryption stuff we studied really made that work.
Yeah, and as you can imagine, when you're dealing with domestic violence, there are some real safety concerns as you're doing this. So that's the kind of last partnership that we've been working on. And we continue to kind of evaluate as we go what works within experiential education, what doesn't work, and how we can continue to further our students' understanding of this AI world that they're going to be practicing in. So ultimately, our goal in any circumstance when we're doing this is we want students that will help close the justice gap by learning to design legal technology that strengthens, as Amy said earlier, rather than hinders access to justice. And now I will turn it over to Maria to talk about our doctrinal courses.
Well, thank you, Dean Norton and Professor Oliver, and it's great to be here with you, and George and members of the Law Review and members of the faculty here. Thank you for having us. So just to kind of set the scene, my background before I joined the full-time faculty at Duquesne Kline was working in industry, and my stick was really working for highly regulated companies. And in those roles, I started to actually explore AI tools because we were actually required to use them by the companies that I worked for. And so as I was teaching my courses, I started to think, how am I going to teach students to use these tools, because this is going to become the expectation and the norm across the board, I believe. And one of the courses that I teach is privacy law. And the animating premise of the course as I designed it is that privacy really is no longer about individual data points. It's really about systems. And we've heard mention of several different types of technology in the presentations today, right? We've learned that an algorithm can screen job applicants. We know that there are systems that can track our locations. Hospital systems have computerized databases that can automatically share information. So these aren't just discrete transactions, right? These are system architectures, and the lawyers who can only read the doctrinal law around concepts like privacy law really can't, and they can't understand how the systems that doctrine governs operate. They can't really do their job effectively. So the course is designed to teach students to do both, to kind of understand doctrinal law, but also understand the systems that doctrinal law governs. And so my privacy law course goes through all of the full doctrinal landscape, FTC Section 5, HIPAA, Gramm-Leach-Bliley, all of the various state data privacy regulations, but every unit asks, how are algorithmic technologies or data-driven practices changing the applications of those frameworks? Because when a machine learning model makes a decision without a person, about a person, right, the elements of a particular privacy claim might change. and the nature of the evidence also changes, and the remedy that a plaintiff is seeking might also be different from when the traditional frameworks were applied in a post-AI era. So the framework that I use with the students is, it's the same legal framework, but it's a new factual and technological landscape, and their job is to learn how to navigate both. And so we begin the class by going through some cases, but we also then pivot very quickly to a simulation crisis exercise that places the students directly in the shoes of an in-house counsel at a corporation that is experiencing a data breach. And so the students have to decide when they're going to communicate information about the data breach as it comes in. They have to decide to whom are they going to communicate that information to. Is it going to be, obviously they have to communicate with IT professionals at the company they're simulated to be working for, but they also have to communicate their findings to mid-level management, executive management, the board of directors, eventually the public, if they have to disclose that there was a breach. And they also have to determine the timing of that, because if they move too quickly in the simulation assignment, then they might trigger some regulatory obligations before they really need to, which is not a good thing. But if they move too slowly, then they might face some accusations of concealment, and that's also not a good thing. So beyond that, we really have a dedicated 2 weeks that we focus on personal data and how personal data is affected by these new algorithmic systems, which is really where we see traditional privacy doctrine, privacy laws or regulations begin to fall apart or begin to fail. And so in one of the previous presentations, there was a discussion about whether we should have kind of a jurisdiction by jurisdiction approach or an omnibus approach. And I tell the students, you can't wait for either. You have to work with the frameworks that we have, right? FTC Section 5 enforcement, Graham-Leach-Bliley, whatever it might be. And you have to have confidence in applying those frameworks to these new facts and these new technologies. And so that's the kind of lawyering that I try to teach the students to do, because the law is always going to be behind the technology, and my job is to teach the students how to close that gap. Now, this is kind of the new feature of the course and something we're very excited about, kind of an evolution in the course for this coming fall. We're going to have what I call an adversarial practicum. And so it's a cryptology thinking practicum that connects directly to what Professor Oliver and Dean Norton were talking about earlier, kind of the coding aspect and relating it to practice. So 2 sections of the course actually are going to simultaneously try to defend a simple system that they've created while attacking the other section's simple system. And so it's not really like a hacking course, but the goal is really to develop three practical skills that all lawyers need. And the first is, again, understanding how systems operate and how they can fail, because you can't evaluate a breach notification if you're a privacy lawyer or do a security audit if you can't conceptualize those topics. The next is mapping risks to legal exposure. And as attorneys, we almost do that heuristically, and we're kind of subtly trained to do that, but really connecting technical vulnerabilities that the client or companies might have that a privacy lawyer is working on behalf of to the regulatory triggers that they activate is what we're practicing there. And then finally, really translating legal standards into operational requirements. So taking a statutory or regulatory obligation and asking, what does a system actually do to have to comply to that? And then going in even further, how as an attorney do I communicate that to the IT professional that I have to work with? Or how do I communicate that to a business stakeholder or an executive or a board of directors that has questions about it. So the students at the end of the course are going to leave with not just the ability to brief cases, but they're going to have the ability to understand systems. They're going to have the ability to perform under pressure because all of this happens, the simulation itself happens in with kind of a ticking clock. And that's a translatable skill that every attorney needs to learn. And then how to think adversarial. And that's not a bad thing. That's just how to anticipate what failures your company or your client's systems might have, how attackers might exploit those, and then what is the law's response to that. So with that, we end the course by asking the students to think big. And this relates to a topic that Professor Oliver alluded to. In the context of privacy law, all of our data in the modern world is encrypted through traditional encryption methods. But with the advent of quantum computing, that all is on pretty shaky ground right now. And what does that mean for our privacy if quantum computers can access traditionally encrypted information in the blink of an eye? And that's kind of where we end the course. And I think that's where I'll end our presentation. And I'll turn it back over to Professor Oliver for some final comments. Thank you.
Thank you. Actually, I have no final comments, just to invite your questions. Yeah, sure.
I actually have a question.
Yeah.
I'll start. Do you have any tips for, say, practicing lawyers or law students here about how to get started in some of these concepts that you were discussing, and some of the courses you've implemented in ways that do-it-yourself type understanding of some of these concepts?
Yeah. I think someone referred. I think it was Kevin's earlier presentation about how you can be trained in a non-traditional setting. That much training now can occur in ways that don't involve, university credentials, and that's me entirely. I guess through universities and like Coursera classes that were produced by professors, you can learn anything now for virtually free, or for very cheap. You can go onto Coursera, you can go onto edX. There are a bunch of other platforms out there that you can self-teach yourself through. I mean, no longer is it like Abe Lincoln by coal oil lantern, like trying to learn out in the frontier. With YouTube, you can get access to the best professors in the world, teaching something you know nothing about, and you don't embarrass yourself by sitting in a class and risking failure, or like letting your fellow students see, I'm very confused by this. You do that in conjunction with a generative AI. I mean, I'll have a video on one screen and Claude on the other. I'll pause the professor and say, I don't understand what he just said. Could you clarify it for me? So pick something that you like today, that you like, hey, I don't know about this. I don't really know much about encryption. Could I learn about encryption? Take an intro class on encryption from one of these services. You want to start to learn to code. One of my favorite, the one that I think we all started on, Dr. Chuck at the University of Michigan has his Python for Everyone class. Like a whole bunch of us started with that class. Just start somewhere. Find yourself an entry point and then do it in conjunction with the generative AI. And anytime you learn one thing in this area, you will necessarily find connections with other things.
The only thing, did I turn it up? The only thing I might add for the practitioner is if you're using some of those bigger platforms like Westlaw, Lexis, ask your vendor. I think I love that you're a must, not a shall here in West Virginia. We are still a shall about technology. Ask them how it works. Ask them what kind of coding that they're using to do the protections. And by doing that, you'll start to see, and then you can go to, ask kind of for the free legal services out there, how does this work? What does it do? And that's another place to start.
Yeah, I would just add, and I don't consider myself really an expert in AI. I'm still learning, just as many people are, but just having a curious mind. And I think that's the best thing that an aspiring attorney could do.
think we could have time for one more question. So if anyone else has a question, I'll bring the mic over to you.
Fantastic talk. Thank you all so much for being here. I really latched on to what you were talking about, Professor McCowan, with the analyzing data breaches and really working on like a real life scenario involved with that. I was recently watching a video about, what times during the year people are busy with billing, and that could be one of those really big upticks when they're dealing with a data breach or something like that. And I was thinking to myself, I know what a data breach is. I could probably look up the law about data breaches, but I don't know if I would know how exactly to handle a data breach. So that was really fascinating. Just a general question for everybody is, what sort of student feedback have you all received about your classes, and have graduates come back and talk to you about how it's helped them in practice?
So wide range. I feel like every year I get 3 or 4 stars. And the best example of that, and I think I've got another real star this year. My first star was the guy who's about to finish Kevin's PhD program. And so some people have gone on to really embrace this. You get 3 or 4 people every year. I've got a couple of students who are this semester going to hopefully compete in a hackathon at the University of Cambridge in large language models and law. They just applied for that. So you get a handful of people every year who really want to pursue it to the next level. You then get kind of a group of people in the middle who I would say are glad they took it, but probably won't pursue it in any real way. And then every year I get 2 or 3 people who absolutely hate me. And that does seem to be kind of following. Our classes have gotten smaller, which is interesting. And I think that they're getting smaller as I'm ramping it up and making it more and more sophisticated. So I do think I'm scaring people off. I don't necessarily like that, but I kind of feel like this is what it's going to take to be prepared to truly have lawyers with tech impact in the world. So that's been my experience.
Yeah, and by the way, as someone who teaches their seminar right before the lunch hour, I do understand what I'm doing right now, so I will talk quick. From my perspective with my students in clinic, in the family law clinic, now that they've graduated, because they know enough of what's under the hood, they're the ones being asked to go do the CLEs on, okay, what are the do's and don'ts of AI in legal practice? So they're taking it from a much more practical standpoint. They're not necessarily doing the coding. Still, they're kind of that middle ground student that Wes is talking about, but they did find it useful in kind of this kind of new era of what it looks like to have AI as part of everyday practice, and what it means and kind of the ethical implications are what they're really focused on.
Yeah, I would just say, every semester, similar to Professor Oliver, I get students that are very interested in privacy law, but then I have some students who are just curious about it, and they might not ever go into actually practicing that area of law, but the course is designed in such a way that there are skills that are transferable and translatable to any area of law. And I do get that feedback from past students that, even though they're not dealing with privacy law directly, they did take some sort of skill away from the course. Yeah.
All right, well, let's give one more hand for the Duquesne team here. Well, thank you all so much.